During your medical malpractice lawsuit, are you going to have to give pretrial testimony more than once? Would you like to know the answer? Come join me on this walk through the neighborhood as I share with you exactly the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, let's say you sued your doctor for medical malpractice. You believe the doctor was careless and caused you significant harm and injury. Your doctor, by the way, denies all of your allegations. Okay, during the course of your lawsuit, the defense attorney, the attorney who represents the doctor whom you have sued, will have an opportunity to question you in a process known as a deposition. During pre-COVID times, this typically would take place in our office, in our conference room. Now, during COVID times, this takes place on a Zoom video call. Now, on that call, I will be on the call, you will be on the call, the defense attorney will be on the call, and also a court stenographer will be on the call to record all of the questions you are asked and all of the answers that you give. The answers that you give actually represent your sworn testimony, and it carries the same exact weight as if you are testifying at the time of trial, in court, in front of a judge, and in front of a jury. Okay, so let's get back to the question I raised in the title of this video. The question was, will you have to give testimony more than once? And in most cases, the answer is, you will not have to give testimony more than once. Now, under what circumstance might you have to give testimony again? I'll tell you when. Let's say you need corrective surgery. Let's say you need significant additional care and treatment as a result of the improper medical care that you received. Now, during the course of your lawsuit, you are questioned by the defense attorney, and he asks you about all the problems that you had, and he asks you about all the medical care and treatment that you received from the time of the wrongdoing up until the time of your deposition. Now, after your deposition is finished, maybe months later, now you are going to have additional care and treatment. You're going to have additional surgery. You're going to need additional procedures. Why? To try and correct the problems that were created by your careless doctor. So now, once we learn that you have undergone significant medical care and treatment, we have to notify the defense. We have to alert them to the fact that you've had additional care and treatment because this gets added to the damages that you are claiming in your case. We are alleging that as a result of the doctor's carelessness, you suffered the following problems and you required the following medical care and treatment. And if you needed additional surgery in order to fix or correct whatever problem you had, yes, we have to tell the defense about the fact that you have now undergone surgical procedures. Not only do we have to tell them about it, we have to give them copies of whatever records we obtain, and we have to give them permission slips, known as authorizations, to go ahead and get the records directly from your treating doctors and from the hospitals where you receive treatment. So now they're going to go through and scour through your medical records. There may be an instance where the defense attorneys say, hey, listen, we need to question you, the injured patient, the injured plaintiff, again. And now we call you up to tell you that you're going to have to give a second deposition. And you're upset, you're angry. You don't understand why the defense would have the ability to go ahead and question you again a second time. Well, you should know something. When they go ahead and question you for the second time, this is not to repeat and rehash and to re-ask all the questions that they asked you during your first deposition. That would not be tolerated. Instead, they're going to pick up from where you last received treatment when you gave testimony the last time. And now they're going to go through in detail exactly what treatment you had, what doctors you went to, why did you have this treatment, what problems were you experiencing, what was your experience like, what treatment did you actually receive, what problems do you have now? Will you need ongoing medical care and treatment? Will you need surgical procedures in the future? So this they will need to understand. And this will only help you. Why? Because it adds to the damages that you are claiming in this case. So although you typically would only give one deposition, the defense has 7 hours, one day in which to question you. There are instances where you, the injured patient, receives additional medical care, receives additional surgical care, and now the defense learns of this information, as they should, and now they say, you know what, we want another deposition to learn exactly what happened, to learn what problems you have now, and do they have to get it? Will they get it? The answer is, yes, they will. And you should know something else. Even if your case is on the trial calendar, and now you have these surgical procedures, and we are waiting for months and months for your case to come on for trial. Once the defense learns that you've received additional significant medical care and treatment, they will ask us to have you produce for a second deposition. And if we refuse, you know what's going to happen? They are now going to enlist the help of the judge. And you know what they're going to say? Judge, Mr. Oginski's client has just had surgery in order to correct the problems that he's claiming in this case. We would like an opportunity to obtain those records, and we'd like an opportunity to question him. We recognize that the case is coming up for trial in the next few months, but we still would like the opportunity to question him to understand the full extent of his damages. And you know what the judge will say? In all likelihood, the judge will say, okay, no problem. Mr. Oginski, you have to produce your client for deposition, and now we have to go ahead and do that. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what really goes on in these medical malpractice cases in New York. You know, I recognize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.